Interviewing a child who may have been sexually abused is very different from the experience of testifying about that interview in a court of law. Kathleen Colborn Fowler is a professor in the School of Social Work and faculty director of Civitas Child and Family Programs, as well as director of the Family Assessment Clinic at the University of Michigan. Dr. Fowler is also a nationally recognized expert in the field of forensic interviewing and has testified in over 100 court cases.
The major difference is this is an adversarial context, and there's no way that you really can understand and appreciate that without having been there, where your credentials will be challenged, your procedures will be challenged, your conclusions will be challenged, and often your credibility and your good name. Okay? And you have to appreciate that that's what the legal context is like.
First, I'm going to ask you to describe your qualifications. Can you tell the jurors your educational background, please?
Sue Ellen Scarnecchia is clinical professor of law at the University of Michigan and supervising attorney in the law school's Child Advocacy Law Clinic.
I think mental health experts have the same concerns that most experts do, at least at the beginning. One, that they're nervous about testifying, regardless of how comfortable you are with yourself and how you might be able to, for instance, present at a professional conference. It's not the same when you're on the stand, serving as a witness, being cross-examined. There aren't too many situations in life when you're publicly cross-examined. And so people express fears and concerns about what that experience is going to be like. Dr. Fowler, how did you first learn of Cynthia's case?
We were called at the clinic by the court and asked if we would be willing to evaluate this case.
To illustrate the experience of testifying in a sexual abuse case and what evaluators should know before entering the courtroom, this videotape will discuss preparing for testimony, giving testimony in court, limits on testimony, particularly hearsay evidence, and how children can be prepared to testify.
Will you please state your name for the record?
Kathleen Cole.
It is important to understand that there are different courts that may be involved in a child sexual abuse case. Juvenile court deals with child protection issues. Family court decides custody and visitation rights. Criminal court is where alleged offenders are prosecuted, and civil suits for damages may be filed by either the victim or the accused. It is also important to note that the rules of evidence and other court procedures vary depending on the type of court. For example, in most criminal trials, the victim must testify, but the testimony of the forensic evaluator will be quite restricted. In contrast, in child protection hearings, children often do not testify, but forensic evaluators do. According to Dr. Fowler, regardless of the legal setting, there is a cardinal rule to keep in mind when testifying in court.
Be prepared, be prepared, be prepared. That is, know your case very well. First of all, know what it is you want to communicate. But secondly, know the background facts. You have to appreciate that the courtroom in many respects is like a stage, and it's the performance that counts. So you can be a great mental health professional and fumble and bumble on the witness stand, and you won't be persuasive to the jury.
Preparation includes a thorough familiarity with the basic case information.
What that means is you have to remember the names of the people involved, their ages. I usually try to have in my head the whole chronology of the case so that I can't be tripped up on cross-examination by somebody who suggests something happened at a time when it didn't happen. And you have to put all that in your head before you get there. The other way in which I prepare is trying to anticipate the likely questions that I'm going to be asked on cross-examination and the possible weaknesses in the case, and have already thought before you get to court about how you're going to respond to that particular question.
You said that you saw Cynthia twice. For how long did you see her?
The first time I saw her for about an hour and a half, and actually also...
When mental health and other professionals appear in court, they will find several types of attorneys. some who will be supportive of their position,
Objection, Your Honor. The witness.
and some who will not.
Objection overruled. Please continue.
When preparing to testify, it is important to know what the respective roles and responsibilities of each of these are.
There's a real different relationship between a mental health expert and the attorney who will be taking your testimony versus the attorney who will be cross-examining you. The attorney who will be taking your testimony hopefully will prepare you. But sometimes when you're called in to testify, for instance, in a child protection case, you're dealing with a very busy prosecutor who will not take the time to sit down with you necessarily and prepare. I always suggest that witnesses advocate for themselves in this setting and insist on preparation time. At least call the attorney and say, just tell me 5 minutes of what you're going to ask me about, so that you can have some sense of how your testimony will be centered. But if they won't prepare you or they can't, the most important thing to do is to read your notes and know your information as best you can. Now, once the attorney prepares you, you need to tell them what you're nervous about and what you're concerned about, and make it explicit so that the attorney is warned ahead of time of what makes you uncomfortable in terms of your findings and conclusions, where your weaknesses are. This is the time to let all of that come out while you're being prepared to testify. When I do a direct examination of a mental health expert, I'm looking to do a few things. First of all, to indicate to the trier of fact, who is either the judge or the jury, that this is a highly qualified witness. First, I'm going to ask you to describe your qualifications. Can you tell the jurors your educational background, please?
I have an AB from Oberlin College. Did graduate work in political science at the University of Chicago. I have a master's degree in social work from the University of Michigan.
With somebody who has a lot of experience like Dr. Fowler, it's easy to do that. The less experience a witness has, the more I need to work with. What is it exactly that qualifies you to do this evaluation and make these conclusions? Witnesses get concerned that they don't have the, for instance, academic credentials or experience credentials that are needed. But in fact, the rule about who can be an expert is very broad. And so as long as you have enough combination of experience and education, you can be qualified as an expert, and that is something that should be prepared ahead of time. So I'm looking in the direct exam to show that this is an expert who knows what he or she is talking about and who can come to these kind of conclusions. I'm also looking to set out what the evaluation was like and what kind of steps the witness took to be able to reach their conclusions. So I'll back up. I won't just ask, what are your conclusions? I'll back up and go through the process to show the judge and to lay a foundation for the cross-examination that this was a high-quality, well-done examination.
This had an impact on her, and I could tell toward the end of the interview that she was fairly conscious of the fact that she was being videotaped.
Can I interrupt you right there, Dr. Fowler, and just ask, why is it that you audio and videotape the interviews?
Videotape is the most important in that gives us both a picture and sound of what it actually takes place. It means that I have to spend less time taking notes. It also means I have a more complete and accurate record of what took place. The reason I also audio tape is frequently I transcribe the audio tape before I actually write the report, and it's easier to transcribe from an audio tape than it is from a video.
Do you also use this videotape in sharing information with other team members?
Yes.
And finally, I'll get to the witness's conclusions, find out how he or she reached the conclusions and what impact those conclusions will have on the case, if any.
In many child protection and divorce cases, an expert would be allowed to express an opinion about sexual abuse. However, in most states, this would not be permitted in a criminal case.
Now, based on the documentation you received, the information you received from other team members, and your own evaluation of this family, do you have an opinion as to whether or not Cynthia has been sexually abused?
I do, yes.
And what is that opinion?
That she has been sexually abused.
One other thing that we try to do during direct examination is undermine the cross-examination. So if I spot that there are weaknesses in my witness's testimony, for instance, he or she cut corners that they shouldn't have cut, I will attempt to bring that out on direct examination and give the witness an opportunity to explain it, as opposed to having the witness first try to explain it on cross-examination where they might be limited to only yes or no responses.
Mr. Ishikawa, do you care to cross-examine the witness?
Yes, Your Honor.
The other thing to think about in preparing for cross-examination is to really be clear about what your recommendation is and why, and then really be willing to stick by it.
Good morning, Dr. Fowler. My name is Dennis Ishikawa. I represent the mother, Christine Smith, in this case.
Good morning.
Dr. Fowler, when Cynthia first came to see you, she was at that time living with her grandmother.
That's correct.
And she was not very pleased with that living situation.
That's correct.
And the reasons you were given for that...
You need to show that you're being honest and that you were neutral when you began to evaluate this child. But presumably your findings and your conclusions have led you to be less than neutral. You've made some decision about what happened to this child or what didn't happen. And that's all right. That's what you're being asked to do. So it's very important to, once you get into the courtroom, feel comfortable about advocating for the position that you've reached without exaggerating your findings and without becoming defensive about your findings.
Now, focusing on Cynthia's more recent statements, you have testified that you believe Cynthia when she says that her stepfather sexually abused her.
Yes.
And do you also believe Cynthia's statements about her friend Tina sexually abusing her?
No.
Okay. She has made those statements, hasn't she?
After when she was feeling pressured to recant, she said that Tina had...
Excuse me, Dr. Fowler, if I could interrupt. Your Honor, Dr. Fowler is not being responsive to my question.
Dr. Fowler, when Mr. Ishikawa asks you a question that calls for a yes or no answer, please answer him stating yes or no. If you feel in your professional opinion that you cannot answer...
The adversarial atmosphere of the courtroom is a far cry from the comfort of the clinic. The nature of the legal system is often a source of discomfort for expert witnesses, but this merely reflects the different goals of different professions.
Now, of course, when it comes to expert testimony, in particular, we could divide that testimony into two categories, medical and expert testimony provided by mental health professionals. Now, Dr.
John Myers is professor of law at the McGeorge School of Law at the University of the Pacific. Professor Myers is an expert in legal issues concerning child abuse.
The ultimate goal of any litigation, whether it's a civil case or a criminal case, is to discover the truth. The way the legal system goes about discovering the truth is through the adversary process of presenting evidence and cross-examining, critiquing, looking at that evidence under a microscope to make sure that it is reliable, and then proceeding on after all the evidence is gathered to try and figure out what the truth is. The truth is designed to emerge from a clash of adversaries in which one side presents its version of the truth and the other side presents its version of the truth. And that's the way that this system is supposed to operate. This is a rather different mode of proceeding than mental health professionals are accustomed to.
Objection, Your Honor. The witness is being asked to testify as to a legal conclusion, and that's a decision that's left to the trier of fact.
Ms. Garnecchia, your response?
Your Honor, I'm not asking for a legal conclusion. I'm asking for her opinion as a mental health expert, and that is admissible under our rules of evidence.
Objection overruled. Please continue.
And your own evaluation of this family.
Professionals who are not familiar with the adversarial nature of the courtroom may find the experience daunting. John Myers offers his advice.
You'll live through this experience. Many more have been there before you and come out not much the worse for wear. Remember, it's the adversary system. It's designed to be confrontational. By and large, we lawyers don't take it personally. We have a job to do. And that job is to point out the weaknesses as well as the strengths in what you have to say. So don't take it personally.
Do you have any from Children's Hospital or anywhere else?
Professor Sally Churchill and social worker Carol Plummer are associates of Dr. Fowler at the University of Michigan Family Assessment Clinic. They recall their experience in the courtroom and offer suggestions for enduring the ordeal.
You need to realize that your function primarily is to educate either the jury or the judge regarding why you've done what you have, why it is that this child's behavior is or is not consistent with sexual abuse. So I think that keeping in mind that you're an educator and that you don't need to be defensive is critical.
I am not on trial. Don't have to feel defensive because I'm a social worker and I know the material that I'm presenting, and I respond with as much authority as I can and clarity, and sometimes with humor. But it's real important that I not feel threatened by what can be seemingly, in any other circumstance, quite offensive interviewing and challenging.
Objection, Your Honor, hearsay.
Ms. Garnecchia, what's your response?
Your Honor, this is admissible under the hearsay exception, which allows statements for purposes of diagnosis and treatment.
Bear in mind that different courts allow different types of testimony from witnesses. One type of testimony that is not permitted is the so-called hearsay evidence.
And what is your opinion? There are limitations placed on expert witnesses in terms of what they can say. One of the biggest limitations that's most frustrating for a mental health expert is the limitation on hearsay evidence. You're often not permitted to say what the child actually told you. And this can be very frustrating because, again, your goal is to tell as much as you can to support your conclusions, but because of hearsay rules, you may not be able to say what the child said or what someone else said to you outside of court. This is something that you should go over as you're being prepared by a prosecutor or whoever's called you to the stand, and know for sure what it is you will likely be able to say and what you won't.
Hearsay evidence is defined as statements or comments made out of court. This includes statements made by a child to a clinician, such as a therapist or social worker. Therefore, out-of-court statements by the child about sexual abuse are hearsay and may not be repeated by others in court unless they fit under one or more of the exceptions to the hearsay rule.
Shall I tell you a little bit about what we're going to do today? Okay.
Whenever you talk to a child who may have been abused, what that child says in psychotherapy or in a forensic interview is often the most important evidence that can be used in later legal proceedings to protect that child. What the child says is, of course, important clinically, and it's important in deciding whether the child has been abused during the interview process. But what mental health professionals perhaps don't realize is that what the child says can be used in court, sometimes in lieu of the child's testimony, to protect the child in criminal or civil proceedings later on if, and here's the if the mental health professionals know what to watch for and document so that they, if you will, preserve the kind of information that the legal system needs to use a child's statements later on in court. And the reason for that is because what a child tells you during an interview, whether it's a forensic evaluation or a purely psychotherapeutic interview, is hearsay. And in every state in the United States, hearsay is not allowed in court.
The key, therefore, is to determine whether a child's statements fall within one or more exceptions to the hearsay rule, which would allow them to be repeated in court.
And at that point, Cynthia made an allegation of sexual abuse and went.
What mental health professionals, I hope, will come increasingly to realize is that they play the key role in determining whether children's hearsay statements can be used in court. And all they have to do to increase the likelihood of that is know what to watch for and document during the interview.
There are 3 specific exceptions to the hearsay rules that forensic evaluators should be aware of.
First is the excited utterance exception to the hearsay rule. Remember, we have to start with the proposition that what a child says during an interview is hearsay, not allowed in court. But if what the child says during an interview is made very shortly after a very startling event, such as child abuse, minutes, maybe up to a couple of hours afterward, then the child's statement may be an excited utterance and admissible. The kinds of things that professionals can watch for. Now, of course, these are usually professionals who are on the scene pretty quickly. Somebody who's in the emergency room, police officer, a social worker from Child Protective Services, something like that, who sees the child shortly following an abusive episode. But the kinds of things they can look for are the nature of the event. Some events are more startling than others. How much time went by between the abuse and the time the interview occurs? That's critically important. Was the child emotionally distraught and upset or calm, for example? Was the child in pain? Was the statement a spontaneous description of something that happened, or did the interviewer pull the statement out of the child with repetitive or perhaps leading questions? Those are the principal factors to look for. The other principal exception to the hearsay rule that applies is called the medical diagnosis or treatment exception. Now, this is a rule, a legal rule, that allows statements to healthcare providers, doctors, nurses, and in many states, psychotherapists as well, but not police officers, and probably not a mental health professional who's doing a purely legal intervention. But if there's some elements of both therapy and forensic assessment, exception might well apply. Basically, if a child makes a statement to a healthcare professional in order to obtain medical care or therapeutic intervention, the child's statements will be admissible, probably in later legal proceedings. And as you know, oftentimes children make very revealing disclosure statements to healthcare providers. What should the professional watch for? Well, basically, make sure that the child understands, when talking to a healthcare provider, the importance of telling the truth. Make sure the child understands your role as a healthcare provider. I'm here to help you. I'm a doctor. I'm a nurse, whatever the case might be. Perhaps do a little testing to see if the child understands the nature of your role. And then document these factors carefully so that if legal proceedings happen later on, you can remember that these were the kinds of factors that were important. Then one last exception. It's sort of a catch-all. And that is, if a child makes a statement that doesn't fit within one of the other pigeonholes, excited utterance, medical diagnosis, or treatment, but it's still a reliable statement, then the judge will consider everything that sheds any light on whether the child was telling the truth. So, from the professional's point of view, anything that you can document that indicates that when a child disclosed, the child was telling the truth, jot it down. It will be invaluable later on in legal proceedings.
Objection overruled. Please continue.
In addition to hearsay evidence, there are also limitations as to what expert witnesses may conclude about the allegation of sexual abuse.
And the question is, Dr. Feller, do you have an opinion as to who was the offender who did sexually abuse Cynthia?
I do.
And who was that?
Her stepfather.
Once again, this varies from state to state and from court to court. So be certain you understand what the limitations are where you will be testifying.
My own view is you should have an opinion. You shouldn't go to court saying, well, these are the data that I collected and make of them what you will. Usually there's some specific questions that the forensic evaluator has been asked to address, and they need to be sure that they've addressed those and can communicate that to the court when they go to court. So in this adversarial arena, what you're partisan towards is not towards, say, the mother's side or the father's side or the state side, but rather you're partisan towards your findings, your opinion in this case. And the implication of that is that that essentially anything you looked at to form that opinion is something that you should be quite willing to communicate to the court.
I think it takes a lot of courage to testify in these cases. You will be cross-examined. Oftentimes someone's freedom is at stake based on what you say. And in order to advocate for the child, you have to have the personal courage to sit there, to withstand the nervousness and perhaps fear, and to just give very honest answers. Judges and juries believe people who admit when they make mistakes, who admit when they don't know something, who understand that there may be gray areas in doing an evaluation. Those are all good things to do if in fact you don't understand something or forget something. And those are the witnesses who carry the most weight in our court system, because when it comes down to it, regardless of your education or your experience, if the judge or the jury believes you, you've then been a very helpful witness to the child.
Adrian, do you know why we're here today? Okay, my name is Judge Jones, and we're here today to find out what a bunch of people have to say about this case.
In addition to the forensic evaluator, the child involved in the case may also be called to testify. In fact, in a criminal case, the child is likely to be the key witness. This child is not an abuse victim, but rather an actress who agreed to participate in the program with her parents' permission for demonstration purposes. When children are required to testify, there are several factors that can affect their willingness to report an incident of abuse. For one, the courtroom is a strange and often intimidating place, making it difficult for some children to reliably offer testimony.
There are lots of things that make it difficult for children to testify in court. First of all, the whole courtroom context, that's a very different room from rooms that most children spend their time in. They don't go to court. They may see court on TV, but they don't usually enter courtrooms. Secondly, it's all grown-ups there. You know, this is not a kid's place. This is a grown-up's place. Third, obviously, the person who, in most cases, the person who allegedly sexually abused them is there. Many times the child has been separated, if a family member, from that person since disclosure. And if it's somebody who's an extrafamilial offender, they haven't, that person hasn't had any access to that child in most cases. So, in a sense, this is often the first time the child has to confront the person since the child disclosed the sexual victimization. The whole process of being asked questions as you sit up there in a little box is really a very foreign experience for most children. They feel, in many cases, quite threatened and challenged by that. And of course, cross-examination is also quite difficult for them. Sitting still for a long time for many children is quite difficult. And that needs to be appreciated when you think about what you're asking kids to do.
Your mom ever talk to you about court? Or courts where they decide whether to put somebody in jail. And I go down, sometimes I talk to the judge. The judge is the one who decides.
When it is likely that a child will testify, the forensic evaluator can help prepare the child for the experience in several ways.
There are a variety of different things that I personally do as a forensic evaluator to begin to concretize the court process. Sometimes we have some cards that actually portray the sort of scenario of the court, and I may use those to introduce the child to the courtroom, to the various players in the court, the judge, the defense attorney, the prosecutor. The pictures also give an opportunity to show the child the place where the child will be sitting. Another thing that I may do is we may actually draw a picture, the child and myself, of the courtroom. They're also, giving the same actors so that the child knows who all the actors are who are going to be present. There are other ways of doing this. There are books that have been produced, usually by courts, that describe the particular court in question that can be used. There are coloring books that can be used. So there are a variety of different kinds of ways of doing this.
You come right through here, Adrian. And this is the courtroom. I want to show you around while nobody's here. When we're here and the case is really going to go on, there are going to be people in all these seats and even some people sitting out here. Okay, so I want to tell you who all those people are going to be and where they're going to be sitting. So the first thing
when a child does go to court, another professional, such as the prosecuting attorney or a witness assistant, might introduce the child to the courtroom itself, giving the child the opportunity to become familiar with the environment and the people he or she will encounter there.
One of the things that's used often by prosecutors and children's attorneys is a tour of the courtroom, so that when no one is in the courtroom, the child has an opportunity to look around, become familiar with the courtroom, see where she's going to sit, look at the microphone and see that it can adjust up and down so that it can be moved down to her height. Talk about how loudly you have to speak in the courtroom to be heard. Talk about where the jury's going to be sitting, what they're going to look like, and then really let her go and try out each of the seats so that she knows what it would be like to be in each of those seats, even the judge's seat, so she can see what it's like to be sitting up on the bench and to see where the witness is in comparison to the judge. If the judge was really here, no one's allowed to walk up here, but since the courtroom's empty, we can come in here. And this is where the judge will sit. You want to take a seat and see what it feels like to sit up here? And then, of course, the kind of preparation I would do with any other witness I would do with the child in terms of letting her know what kind of questions I'm going to be asking, preparing her for cross-examination, giving her some hints to, for instance, focus on someone she's comfortable with in the courtroom if she gets nervous. You feel pretty comfortable? Okay. All right, let's practice for a minute. And when I ask you the questions, I'm going to stand over here because there's going to be members of the jury sitting here, the people that are going to decide the case. They're going to be up on this bench. So I'm going to stand over here, and when you answer my questions, you'll be looking right at the jury. That way they can see you better, okay?
There are other things that you need to do as well. One is to let the child know that probably the defendant is going to be there. That is, the person who is accused will be there. That they won't be allowed to do anything to the child, but they will be present in the courtroom. That there will be a bailiff there or a sheriff or somebody, a policeman will be there to prevent the person from harming the child. And that the child, in fact, doesn't have to look at that person. The child can look away except when the child is required to identify the person.
Because of their age, many children are at a disadvantage when cross-examined. Remind the child that the job of the defense attorney is to convince the judge or the jury that the event never happened.
I talk about that there will be an attorney who will ask you questions, and then there will be another attorney, and that's, you know, Mr. Jones's attorney. And know that he might ask you some hard questions, and he might ask you some trick questions. And if you don't understand the questions, you tell him. If you feel like he's trying to scare you, you tell the judge that. So that you prepare the child to not be bowled over by what may well be a vigorous cross-examination. Another thing that to me is important in dealing with the court process is to appreciate that you're there to educate. You're not the ultimate decision maker. That the judge or the jury will be listening to your testimony along with a lot of other testimony in many cases. And they're the people who sort of pull all the pieces together and come up with the final opinion. It's not you. You go and you present your particular view. But I think it helps, at least it helps me in sort of dealing with some of my own sort of personal issues around going to court, to appreciate that my role is that of an educator with a particular body of information and of an opinion based on that, but I'm not in charge of the court.
Remember that unless you're willing to go to court and tell what you know, either as an expert who's providing their judgment about whether a child was abused, or as a non-expert who is there simply to repeat what a child said, unless you're willing to do that, to fill that difficult role, the legal system doesn't have a prayer of protecting children. We can't do the job of protecting children unless professionals who are willing to go into court and go through the rigors of direct and cross-examination.